Okay, wonderful. We'll kick things off then. So this week we're going to be moving on from our principal workshops and talking about something new. So this week we're talking about law and criminal justice in debating. In particular, this is a workshop that's going to come in two parts. In the first part, we're going to go through what you might have heard of before as the 5 pillars of the criminal justice system. We have 4 of them because we've grouped 2 of them together. We want to talk about 4 kind of common impacts that you'll see in debates about law and criminal justice, how it is you might weigh between them, how it is you might reach them. In the second part of the workshop, then, we're going to talk about the process of criminal justice. So that is moving through the various parts of the criminal justice system, from trial through prison, through life after prison, and what common pieces of analysis you might see that is, or what common characterization you might see that are useful in debates at various parts of that process. As usual, I have Zoom chat open on my left monitor, so if you have any questions as we're going, please feel free to drop those into the Zoom chat and I'll answer them as we go. Otherwise, we'll jump in and we'll get started by talking about the purposes of the criminal justice system. So to start with, let's talk about public protection. So broadly, public protection involves 2 claims, incarceration and deterrence, both of whose goal is to, in some sense, protect the public from crimes in some capacity. Let's start by talking about incarceration. So in incarceration, our goal is to essentially prevent the criminal who has committed a crime from being able to commit that crime again, usually by, for example, by imprisoning them so that they obviously don't have the actual capacity to recommit that crime. I think one of the problems with the application of incarceration in debating, and the thing that I then want to talk about and explain, is that in order to justify why incarceration is necessary, or at least why it is a useful thing to be doing in the criminal justice system, one of the things that you need to be able to prove is that reoffense is something that's likely to happen. Because obviously, if someone commits a one-off crime and they're never going to commit that crime again, then incarceration isn't going to be something that's particularly useful in preventing more harms from occurring. So what we want to start off by doing is giving you 3 reasons why reoffense is likely, at least for many crimes, and therefore why incarceration is a useful goal in the criminal justice system, and therefore also a useful impact or a useful mechanism by which to reach impacts in debates about that criminal justice system. So broadly 3 reasons then, we're going to give you why people might reoffend in instances of having committed a crime. The first is what we've labeled as situational reasons. That is, it is often the case for people who commit crimes that they commit them largely because of environmental factors around them. That is to say, for example, you should keep in mind, for example, crimes of necessity here, i.e. stealing because you face poverty, or maybe, I don't know, entering into a gang because it is the only option within your neighborhood in order to gain some degree of protection, and so on. I think the problem then that you are pointing to that leads to reoffense is that whilst it might be that you have been caught and potentially even face some form of punishment that doesn't incarcerate you for a particular crime, all of those environmental or situational reasons still apply to you. And therefore, it's the case that you're likely to reoffend because the reason that you offended before still actually drives you as a motivator. Secondly, on reasons why it is that you might reoffend, there are various patterns of behavior that might accrue here. That is, for example, if I am someone who has committed a crime, I don't know, I've assaulted someone in public as a crime of passion because I was angry in that instance, this often speaks to patterns of behavior that I have that led to me committing that crime. That is, in the example I gave you, I might just be someone who is predisposed to bursts of anger and is bad at controlling that anger. For various reasons, I formed habits that means I'm likely to enact the results of that emotional response onto others. What that means is that the crime that I've committed wasn't one that was driven rationally. It wasn't one that's one-off. Rather, it was one that was driven by patterns of behavior that I myself have internally that I've learned over time. And those patterns of behavior haven't changed either, just by the fact that a particular crime that I've committed has come to light. And that means I'm likely to reoffend. The third, and I think the most obvious in debates, the one that comes up the most, I guess, is that there is just a lack of consequences. That is, if we don't incarcerate people, then they think that they've gotten away with the crime, that it was something that actually was something that was very good for them when they did it, because they gain some degree of benefit, presumably, from committing that crime. And if they don't face equivalent punishment or incarceration, they're likely to feel like that was a decision that was worthwhile, and therefore is worthwhile them taking again. If they feel that lack of consequences, that means that they are likely to reoffend. Obviously, this third one also to some degree speaks to deterrence, because this is deterrence for the criminal from committing the crime again, but it at least tells you that reoffense to some extent is likely, and therefore incarceration is a useful thing to be doing in the criminal justice system. Secondly, and I think kind of more interestingly, usually in debates, the one where a lot more of the clash in debates arises in terms of public protection, is deterrence. That is, both trying to prevent the criminal who has committed the crime from committing that same crime in future by making it clear to them that there is some form of punishment, but also doing the same thing for society as a whole. That is, trying to preemptively stop people from committing crimes by convincing them that the crimes won't be worth the punishment that they would accrue. What I want to do here then is go through how this clash might play out, give you some reasons why it is deterrence might be effective as a mechanism, and also some reasons why deterrence might not be effective. Especially on that second thing, I think this is something that's often left a little untouched in debates, where there are often good reasons you can give that mitigate the effect of deterrence as a mechanism in the criminal justice system. So to start with then, why is it that deterrence might be effective? I think there's two reasons to give here. The first, and I think quite straightforward one, is simply that fear of prison or punishment is something that affects how people behave. That is, if I am someone who is committing a crime or considering committing a crime, and I understand that if I am caught for that crime, I will face some large degree of punishment. Maybe I'll be locked up in prison for years, maybe I'll have to pay a particularly large fine or whatever. These things factor into my decision-making calculus. I don't want to accrue those punishments because they are things that potentially scare me or I know would affect me negatively, and therefore make me less likely to commit that crime because it just doesn't feel worthwhile to me. Secondly, though, in terms of why deterrence might work, the deterrent effect also speaks to how it is we consider crimes societally. That is, when crimes have high punishment, the way we discuss them makes them seem less permissible, because we see that punishment not just as a thing that we are doing to that individual criminal, but also as a commentary on how bad the action that they took was. So when, for example, in the media, we see certain crimes achieving very high punishments, this means that it's not just the case that potential criminals who are considering committing that crime think about that punishment and for fear of that punishment won't commit that action, but also as a society as a whole, we internalize to some extent the idea that that crime in particular is something that is impermissible. What that means is even when I'm not actively considering the punishment, I am less likely to commit that crime because it's something that I've internalized is less societally acceptable and therefore is further away from the behaviors that I might want to take. And that means that the deterrent effect can even work to some extent if I don't consider the punishment directly at the time that I am committing the crime. Having said that, though, why might the deterrent effect might not be as effective as you might think? Three reasons that I'm going to give here. Two of which I think come up in debates very regularly, the third of which I don't think comes up in debates maybe as much as it should. Let's start with the first two then. So reason number one, the one I've kind of hinted at when talking about the reasons why deterrence might be effective, is that often when people commit a crime, they aren't properly thinking about the punishment. These fall into broadly two categories. The first is that you might be in an instance of, for example, committing a crime of passion. You're not making that decision rationally when you decide to commit that crime. And therefore, you aren't really making the rational trade-off between the benefits that committing that crime will bring you and the punishment that it will entail at all. And therefore, it doesn't matter what the punishment is because you're just not thinking about it. And therefore, deterrence obviously cannot have an effect on you. Secondly, though, often it's the case that punishment just feels less proximate to people committing crimes than the potential benefits do. So to give an example to try to make this clearer, if I am someone who is very hungry, I'm starving, and I'm going to steal some food in order to feed myself, it probably doesn't matter all that much what the punishment for that is to me, because that hunger is something that's more proximate to me than the abstract notion of punishment if I were to be caught. That is, I feel the hunger inside me right now, and it's something that dominates my mind because it's all I can think about. Whereas the punishment is something that's much further away. Obviously, to some extent, what the punishment is does still matter here, but it comes at a heavily discounted rate, because I'm going to think about the punishment as being much less important than the reasons that I'm committing the crime in that instance, because those reasons are just much closer and more tangible to me. Secondly, in reasons why it is that deterrence might not be effective, is just the very simple claim that often when you commit a crime, you commit it because you don't think you're going to get caught, right? You're not planning to be caught for that crime and therefore to accrue that punishment. The plan is to commit the crime and to get away with it. And therefore, it doesn't matter all that much in lots of instances what the punishment is going to be, because your intention is just not to get caught for that crime. And therefore, in at least your rational calculus, your assumption is that you will never actually accrue that punishment in the first place. Thirdly, and this is the one that I think comes up maybe less than it potentially should, is the claim that prison sentences in particular are something that are hard to conceptualize the depth of harm that comes from them. I think this is broadly for two reasons. The first is that I don't think the general public has a very good conception of what life inside prison is like. We're going to touch a lot more later on what the depth of harm of life inside prison might be, but I think it's worth when we get there just checking back to this mechanism and comparing that to what you might think that individual criminals might expect life in prison to be like. Secondly, though, even if I have a good understanding of what life in prison might be like, it's hard for me to conceptualize the sentencing that I'm given. The reason for this is that we give sentences typically in numbers of years, right? So I might say that you are being sentenced to 2 years in prison, and it's hard for you to conceptualize exactly how long that is because the number is small and you don't have a good idea of what it's like to live for 2 years straight. I think there's two things going on here. One, the choice of number is small and therefore underplays the amount of sentencing that you're accruing in comparison to, for example, me saying the same thing as being 730 days in prison, whilst these are equivalent, makes the sentencing sound far worse. Secondly, though, and this is the same kind of bias that we talked about last week when we were talking about conception of large numbers, in general, humans are bad at conceiving of what it's like to be, for example, in prison for a large amount of time in a row. And so we usually think about the harm that accrues maybe in the first couple of days, and then we just say that happens for a really long time. But the difference then between, for example, 2 or 3 years doesn't really have the effect of that extra year in our mind, because we can't conceive of what it is that extra year does for us. That's all of the mechanisms that we wanted to talk about on deterrence, why it might be effective, why it might be ineffective, and therefore everything we were going to talk about on kind of public protection as an impact so far, before we at least come to the second section. Before I move on, are there any questions anyone wants to ask about public protection at this point? Okay. If not, there's nothing coming in the Zoom chat. Maybe people are typing. I will come back to those questions if they are. Otherwise, I'm going to move on to talk about rehabilitation next. So we're going to talk in detail about the process of rehabilitation later, because we're going to talk about what life inside prison might be like. At this point then, all we want to talk about is why it is that we care about rehabilitation in the first place. Why is rehabilitation something you ought to find valuable in debates about the criminal justice system? Broadly, two reasons here. The first is that obviously rehabilitation is something that serves to prevent future crimes. That is, if I'm able to rehabilitate a criminal, I'm able to change their decision-making calculus in future such that they don't feel the need to commit crimes, and therefore I'm able to alleviate harms that might have accrued to the public in future. So this is kind of a public protection mechanism. It's just one that comes down the road. Obviously, though, if this was absolutely the only thing that we cared about, then we might want to just lock people up forever, because that would equally prevent future crimes. I think the reason that you don't just do that is that the state, to some degree, also has a duty not just to the public, but also often towards the individual that has committed the crime. The most common way that you're able to argue this within debates is to say that when individuals commit crimes, they did not have complete agency to make the decision that led to them committing that crime. Most clearly, for example, this would be in the case of crimes of necessity, where the state has, for example, created situations of poverty and failed to alleviate them that drove people to feel the need to commit crimes in order to try to alleviate their own situation. But also, for example, very often in other instances of crime, when it's just about the internal thought process that you have rather than the situational behaviors around you. Again, the state is someone who has failed, for example, to give you potentially, for example, correct education and so on, and therefore is to some extent responsible for the crimes that you've committed and therefore the harms that you later accrue. That means that the state, to some extent, has an obligation not just towards the victim or towards the public, but also towards the criminal. And therefore, we owe them, to some extent, a degree of rehabilitation, because that's the thing we ought to have given them in the first place, the ability to live a life that didn't necessitate them committing crimes. And so this is almost even a reparatory duty. So Chris has asked me a question in the chat. Chris, I'm going to come back to that on the next slide when we discuss retribution. Moving on, if there are no other questions then to the next slide, we're now going to talk about victim closure. Victim closure is something I want to talk about in quite a bit more detail. And the reason is that there's a common problem I think that debaters face when they try to argue that victim closure is something that we ought to care about in debating. And that problem is that arguments about victim closure usually get marginalized fairly easily. That is, it's hard, I think, to establish, or at least lots of teams fail to establish, that the effect on victims of failing to, for example, give adequate punishment for them to get closure is that the victims, just kind of upset for a while. They've already suffered the harm of the crime, and the additional harm that they're gaining from not seeing punishment is just a minor, emotional response. It's not anything that's really significant. It's certainly less significant than public protection. It's probably less significant than, for example, rehabilitation, if that's the ability to get out of prison in the first place, given the things we're going to say about how bad prison is later on, and therefore maybe we ought not care about victim closure that much. Obviously, there's not lots more written on this slide, so I don't think that's a complete take on victim closure. What I want to do then now is talk about how you might circumvent those issues. I think there's broadly two things you can do. The first is you need to clearly explain why it is that the lack of punishment actually affects victims considerably. Three things I want to say here. One, notice that we are socialized in order to understand that when a wrong is done, the correct response to that wrong is that punishment will be doled out in response to it. So, for example, as a child, when you do something wrong, your parents punish you as a response to that wrong. And so you're socially conditioned to expect that when wrongs are done, punishment will be what meets them. What that means is that when punishment does not accrue, the victim feels like their pain has not been recognized, that they've been disrespected. Because if a severe wrong was done to them, then they've been socially conditioned to expect that the response to that ought to be, if that wrong was a significant one, that the person who committed that wrong would be punished in some meaningful sense. What that means is when that punishment doesn't happen, that victim feels lots of emotional responses. They feel anger, they feel pain, they feel unrecognized. The end effect of this isn't just that emotional response. It's that the crime that was committed is more likely to stay constantly on the victim's mind. That is, rather than being able to move on, for example, when they lie in bed at night, they're likely to, again, feel that anger and that pain, and they're likely, therefore, to go over the crime again and again in their head. And this carves grooves in their mind where they're, therefore, more likely to think about those issues. What that means is that the victim's life ends up being debilitated in two ways that could have been avoided. Firstly, I think in general, the victim is likely to just feel, for example, fear more often when they try to engage in activities. So, for example, if I were the victim of a mugging and I've been carving those grooves in my mind by going over the event again and again, I'm likely to feel more likely to feel when I go out for a walk, like that mugging is something that could happen to me. The reason for this isn't that that mugging has become any more likely. I had probably the exact same chance of being mugged as I had before. The difference is that the risk feels more proximate to me. because I've spent more time thinking about it. And therefore, in my internal thought process, it feels like something that's more likely because it dominates more of my thoughts. And that means that just when I go out for a walk now, I'm more likely to be worried about getting mugged because I spent so much more time thinking about that. And therefore, I'm more likely to be fearful. Secondly, though, the emotional response limits your capacity to enjoy other activities. That is, if you're trying to enjoy something else, but all you can feel is the anger or the pain at the crime that was committed to you and was not properly punished, then you can't enjoy that other thing because you can't ever fully be in that moment because you're experiencing this other negative emotional response instead. And so it's not just that you have some small negative emotional response, but rather you can't even enjoy the life that you deserve to have until the state has actually doled out the appropriate punishment. What I want to say here, finally then, is that whilst it is the case, these mechanisms allow you to increase the degree of impact to the victim, it's not always, or necessarily even often the case, that these on a kind of purely utilitarian basis are going to outweigh, for example, public protection as an impact. That means that you usually need some reason that we care about the victim in particular, some kind of principled obligation, in order to be able to make this the most convincing thing in the debate. So why do we care about the victim in a principled manner? The thing I would say here is that the victim was limited by the state in their capacity to exercise self-defense, right? When a crime happened to them, they didn't protect themselves adequately from that crime, both because, for example, laws might have constrained their actions in that instance, but also because the expectation that the law would be upheld meant that they probably didn't take preventative measures that they otherwise could have taken, that meant that that crime would not have affected them. That is, you've outsourced your capacity to defend yourself from crimes to the state. And in this instance, the state has failed to exercise that self-defense on behalf of you. That means that there is a reparatory duty towards the victim that exists on behalf of the state here. It needs to try to put the victim back into the position that victim would have been if that crime hadn't been committed, or as close to that position as possible. So you should see the reparatory duty stuff we talked about in the principal workshop last week. What that means is, obviously, for example, if money was taken, we might do things like levy fines on the convict in order to try to restore that money to the victim, but also we should do things towards restoring the emotional state that that victim ought to have had. And therefore, the kind of punishment, for the reasons we said earlier, is something that is actually owed to the victim. It is owed that you see that that criminal is punished. Finally, in terms of purposes of the criminal justice system, I want to talk briefly about retribution, and then I'll pause for questions. The thing I want to say about retribution is that principally justifying retribution in general is something that's very, very difficult. Usually, this has to be something that's motion specific, i.e., you have to be in a motion that either requires you to get something very particular about retribution that exists, or be an emotion that's going to lead the other side to wanting to, for strategic reasons, concede to some extent that retribution is something that you're going to care about. In general, I think it's very hard to convince the judges at a principle level that we ought care just about harming a criminal because they harm someone else. What that means is that the advice I want to give is that this is something you should avoid as an impact unless absolutely necessary. It's usually not something that I think is particularly effective. And in almost every criminal justice motion that you will end up debating, the previous three kinds of impacts that we talked about are sufficient for you to have a quite deep and interesting debate where there's lots of room to win. And so on that basis, I don't think retribution is necessarily the most useful metric to be talking about. Before we move on to the second part of the workshop then, I just want to answer whatever questions there are. So if you have them, please feel free to type them in the chat. In the meantime, there was a question from Chris, which is there a way to run both rehabilitation and retribution without having tension in the case? So the first comment to make on this, and the reason I held off on answering this, is obviously to some extent, if I don't want to run retribution at all, then the answer to this question should be, I don't particularly care, because the advice I would give is just not to run retribution. However, having said that, I do think that these things can be principally consistent. The reason is that you can have obligations that push in various directions, and you want to maximize your ability to meet all of these obligations. Rehabilitation is something that presumably occurs in the long term. It might be, for example, that I can simultaneously, to some degree, reach retribution by punishing the person who committed that crime and have that punishment achieve rehabilitation, i.e., I have specific obligations to various people, the obligation to the victim to some extent to provide them with retribution, the obligation to the offender to provide them with rehabilitation. And I am able to meet both of those obligations by performing some degree of punishment. And to that extent, yes, you can run both of these things at the same time. There's no inherent tension there. Are there any other questions about this first half of the workshop?
Yeah, I wanted to ask about rehabilitation and kind of retribution, but on larger scale. So, for example, reparations. How can you how can do them together? If you know what I mean, like, because which word? Oh, there are 3 words on R, and I get confused between them now. Reparations are kind of like wrongdoings of a country to another like country or a group of individuals in the country, right? But we also say that retribution is not principally good argument, but at the same time reparations are.
Yeah, so reparations doesn't just mean, at least in the way it's used in debating, countries paying something back to some group within the country. Rather, reparations refers to something we talked about last week, which is the reparatory principle, which is the claim that when a wrong is done, you have an obligation to restore the world to the state as if that wrong hadn't been done. So, for example, think if your TV is stolen from you, the person who stole it probably has an obligation to return it to you. And then we're using this as a justification, for example, in the situation of the victim, to say that the state failed to defend that victim's self-defense, and that would meant a wrong was done to that victim, and therefore the state has a duty to restore to that victim the situation they would have been if it weren't for that wrong being done. Hopefully that makes sense. There is one...
that how, yeah, just sorry. It's just how does it, like, isn't it on a larger scale of saying it's a retribution basically? Like, what's the difference between retribution and reparations? Because it's like, for me, they like basically a very similar thing.
No, so these go in opposite directions, I think. In reparations, you return something to someone that was taken from them. In retribution, the claim is that you ought to punish people for a wrong that they've done. That is, one is a kind of positive claim in which you restore the world to its moral track, if you like. In the other, you just make the claim that because someone has done a wrong, you ought to harm them too. So rather than kind of doing a right in some sense, you are doing a further harm. Having said that, at this point, so there's another question from Chris. There are lots of, which is also, I believe, about retribution, on the basis that we, like, the advice we're giving you is that retribution isn't a principle that you are going to be able to, I think, very easily establish in debates. I don't want to spend lots of this time in this workshop talking about how retribution is consistent with other claims, because I don't think it's potentially the best use of time. Maybe if we have time at the end, we'll come back to this. But otherwise, I think we'll move on for now to the second half of the workshop, for which I believe I'm handing over to Lucie.
Yeah, I'm just going to check my audio is good. Yeah. Cool. Excellent. Okay, so in the second half, we're going to talk more about the more practical stuff, let's say, and go through the process of criminal justice, from the trial process to, say, the prison system, and then to the life after prison, and going through a couple of, I would say, important arguments or characterizations that you might be using quite often when you're debating related motions. So starting with the trial process, the first thing I would note is that there's a sort of an overarching theme, and of the characterization I'm going to be talking about now, is that often criminal justice motions that are related to the trial process often have to do with, say, suggesting some sort of policies that are correct, like trying to correct existing biases and existing problems in the trial process. So it's very useful for you to know how to characterize and explain what those problems and biases in the trial process are, so you can explain how exactly the motion is correcting them, or if you are on all power, it's making them worse / not actually helping them at all. Is that a question?
Yes.
Yeah,
after you're done, only then will I start.
Sorry?
After you're done explaining, I can wait.
Okay, we probably going to have like a Q&A section after the thing. So if you want to keep the question for them, then that would be also good. But if it's something very specific to a slide, I'm also going to ask afterwards. Cool. So yeah, starting with somewhat the very first thing, even before the trial starts, the first kind of bias you can point out is bias during the evidence gathering itself. So it can be pointed out that very often there exists some sort of confirmation bias and a tendency to tunnel vision a particular subject. For example, if you have police, that is often also underfunded, meaning that they do not have the resources to actually do really, really proper investigation. Very often when you have, for example, racial biases or like socioeconomic background biases, there tends to be a tendency among people to pick a particular subject that fits that description and kind of tunnel vision and sort of focus on the evidence that is confirming the guilt of that particular subject and kind of filtering out the one that doesn't. So very often what happens is, for example, that the individuals who are investigating are able to find like specific witnesses who are able to say that they've actually seen that subject, that particular suspect, and they are able to pick these, and then you ignore things that would go against that, for example, some sort of alibis, paying less attention to them, etc. I wrote subject, I meant suspect. So this is one way in which the bias often occurs even before the trial exists, even starts, and which is how you can also point out why very often like there is a tendency to have particular groups of people overrepresented in trial processes in the first place. The second thing then to talk about specifically in trials are lawyers. So the one thing that very often gets addressed in debates is the role of wealth. So talking about this is useful for any motion that is related to rich actors in court and sort of limiting their power. So it can be rich people. So, for example, the motion this House would require all defendants in criminal cases to be represented only by state-employed lawyers is a motion where if you are on go of that motion, you are required to explain why they're under status quo, where people can pay and pick a private lawyer. There is some sort of injustice and there's some sort of advantage that rich people would have. Obviously, it also can apply to other rich actors, for example, companies, and why it is bad that companies are able to buy really, really massive amounts of lawyers that are able to help them. So the claim then is that rich people, obviously, given that they have money or companies, can afford better lawyers. I think often the problem that people have when it comes to arguing this is that they do not explain why that actually matters. So what is it that the lawyer actually does for you? What advantages might it have to have a good lawyer? Because even if I'm buying this claim, if I'm not sure what difference it actually makes for a rich person to have a really good lawyer and for a poor person to have not as good lawyer, it is unclear how big that impact is. So before we're gonna give you a big list of things that a lawyer can do for you, just to ask if people have any ideas, what do people think that a lawyer does for the person they are defending, and what advantages might it have to be able to get a really good lawyer? So if you want to unmute yourself, that's fine. If you want to type it in the chat or DM me, that's also fine. I'm going to give you a couple seconds to think.
Am I audible?
Yeah.
Yeah. So in general, lawyers that represent the court are usually barristers, and the main thing that they do is they go through the facts of the case and try and find arguments as to why or not, as to why their client is not guilty. So usually that would either be finding loopholes in different laws or different exclusion clauses and things like that exist in the law, or like in contracts and things like that exist. More often than not, it will also include trying to find reasons why the prosecution would say that their client is guilty, and then trying to disprove that on the face of the facts.
Yeah, that's a lot of things that I think all of them are going to go through them. So yeah, those are all good answers. There is some stuff in the chat. Chris says, roughly a lot of the similar things: going through evidence, questioning witnesses, which you can do better if you are good, dedicate time to the case, build rapport with the judge or jury, be more eloquent, etc. So that's also a bunch of good things. Julia says that private lawyers typically have more time to pay attention to your case because you pay them per hour. That is definitely true. So if you can also think of what is it that the lawyer is going to be doing in that time, and why specifically more time is helpful. So maybe if you have an extra addition to that, that would be also helpful, but it's definitely true. Olga says, and this is very good, look for legal loopholes and find a bunch of precedents where similar cases have resulted in favorable outcome. Yeah. And better and more lawyers are probably better at establishing more doubt. Yeah. Anything else that people can think of now? Yeah, is that?
So actually, I'm not sure about this, but lawyers basically, are trained to present the case in a way which goes above and beyond just presentation of facts. They can build a very convincing rationale. It's the way they have been just trained, the legal training. I mean, that is that the way we are having a workshop here, we're seeing how to really come up with arguments and how to, build proper rebuttals and everything. There's structure to it that a normal layman may not be able to come up with that easily. And I think that's what the biggest asset is.
Yeah. I think that also definitely makes sense. So Julia also says that with more time, they can do things like come up with better arguments, spend more time on convincing jury members, etc. That is fair. Olga says bully witnesses if necessary. And Anna says maybe also come from similar backgrounds of judges, for example, elite schools know what frameworks would work better. So yeah, that's definitely also true. Look for more people with similar cases to establish a stronger case. Yeah, so that's already, I think Chris also mentioned it in terms of precedents. Yeah, Melinda, do you want to unmute?
Yeah, I guess they can also pay for interviews. If it's a publicized case, they can pay for interviews with interviewers who are sympathetic to the victim, publicize the case in the victims, the accusers. No, wait, who is the person? The person who is allegedly committed the crime. They can make them more sympathetic in the media, which also influences how the jury and the judge looks at them.
Yeah. And then Chris says, dedicate the time need to fight all parts of the bail procedure, make better recommendations for plea agreements, guilt pleas. Yeah, all of this is really good. So good that people have a lot of ideas. Can I have the next slide then? Cool. So I think people went through most of what we actually came up with, probably even more. So just to go through it, obviously quicker because we've already talked. So I think the first thing we had is kinds of procedural advice. So for example, the fact that a very good lawyer can spend, as people pointed out, more time with you that can spend with preparing you and, for example, protecting you from making mistakes like different kinds of self-incrimination, for example, during testimonies. It's also things like looking into evidence. I think we've talked about the, like a lot of people mentioned this about precedents and looking into previous cases. This is definitely true. We have a case study that we found about that illustrates this quite nicely. So in the UK, there used to be a shaken baby syndrome, which was a thing that did happen to babies. And there was a study and research that was respected. That said that this is something that is a fault of the parents of the mother of that baby, meaning that there tended to be a very formulaic response in trials to that case. When the shaken baby syndrome happened, it very formulaically always ended with the mother being convicted because it was just said that this is something that the mother causes. This changed at the point when this happened to someone very, very wealthy, where a very, very wealthy woman was able to get good lawyers who were able to pay independent researchers who went again through those studies and were able to establish that, in fact, this is not something that is fault of the mother in every case, and making it significantly more doubtful. What this meant is that this changed and the cases were no longer seen as really formulaic, and there needed to be much more evidence established in future cases. So this proves what we were talking about, i.e. why when you are wealthy, you are more likely to have people who are able to do things like pay researchers and just change otherwise very a very rigid outcome. But I think B, reason why this can be way this can be used is you can prove trickle-down effects, i.e. explaining why even if you are not wealthy, the fact that wealthy people can pay for lawyers can somewhat benefit you. Meaning that like after this wealthy woman was able to pay the researchers, even people who were not as wealthy but went to court for the same reason still benefited from setting the precedent and for the fact that they were not immediately convicted as a result of the new study being established. So this is a way that you can like point out, like, look, rich people, they actually help trickle down that nice stuff. Thirdly, people talked about it, the charisma, specific know-how, like for example, when it comes to the questioning witnesses, etc., etc. And obviously the abilities to find different technicalities, loopholes in law, which requires time and resources. Again, people pointed out you can pay them by hour, they can spend a lot of time going through it, or like specialist knowledge that obviously you might have to be willing to pay for someone who has some sort of specific knowledge that is not very common, meaning that you need to pay more to get that particular person. Cool. So yeah, well done, everyone. That was, I think everyone had a quite good idea on this. So the claim that we would make in terms of to kind of say balance this out and being able to have a response is to point out that it is, whilst obviously wealthy people can have the capacity to get these really good lawyers, I think we can also point out that it is not just wealthy people who can get them, i.e. even non-wealthy people might be able to get a good lawyer. This is for two reasons. I think you can point out that there are lawyers who do pro bono cases. We gave two reasons that you can give as to why they have the incentive to do it. I think there's one that is something that doesn't really sell in debate land, and that's just that not everyone is a lizard, and sometimes people just do things because they are not awful people. But if you want to be more cynical and more debate landy, then you might say things like, often when people go into criminal law, they have a conception of themselves as someone who is going to be a good person, someone who's going to be like fighting against crime and protecting innocent people, blah, blah, all these things. Given that like sooner or later you are probably going to, and especially if you are a really good lawyer who's getting a lot of money, you probably diverted from that track and started to focus a lot on the sort of financial benefit for yourself, meaning that because you still want to confirm the conception that you have of yourself as a good person and alleviate the kind of guilt that you probably have, you are likely to be doing things like taking pro bono cases in order to get that guilt alleviation. But secondly, also, for example, if you are a minority lawyer, you might have a personal experience, you might be more empathetic to individuals who are from the same background, who are poor, and like, given that you know that they often have the sort of like there is often bias against them, meaning like they need someone and good lawyer that is able to protect them. Like for that reason, you also might have an incentive to do it. And obviously there are also charities that want to provide legal advice, etc., etc. So you can point out that, for example, I think this matters for the motion before about replacing all private lawyers with lawyers with state-employed lawyers. You might point out that this can also be on opposition. You can point out this can be bad for poor people and minorities because you're also taking away the opportunity to get, for example, the pro bono lawyers from them as a result of that. The last thing in terms of lawyers is talking about the role of identity. Again, there is sometimes motions that have to do with individuals being represented by someone who is from the same background or different background. So explaining why is it important to be able to pick a lawyer or have a lawyer who comes from a similar background. Two reasons that you can give as to why that would be a good thing. I think the first one is just pointing out the problem that often exists with confirmation bias or the lack of empathy that someone from a majority group might have towards their minority client. That is not that you're going to be treating your client as if they are guilty, but it's more like, because you have that pre-existing prejudices and pre-existing stigma, you might just like subconsciously believe that there is less likelihood of you being successful in trying to find the evidence that protects your client. Because you kind of do not believe that you're going to be successful, you are less likely to be dedicating enough time, you're less likely to commit actually to protecting your client properly. For that reason, there is often a problem with these individuals not being represented properly or being suggested, for example, a plea deal, even though they shouldn't be. The second thing, and that's more from the side of the individual who is accused, the fact that you have trust towards your lawyer, like again, you can do the analysis about why if you are a minority person, you may be less likely to have bad relationship with members of the majority because maybe you had, like, obviously you probably experienced some level of say racism, because if you are more likely to trust the lawyer because they come from the same background, you are more likely to follow their advice, and given that we explained that is helpful if you are able to follow their advice, for example, in how you meant to behave in the testimony, etc., etc. If you are more likely to do it, then obviously the outcome for you is going to be better. Or you are more likely to, for example, provide them information that lawyer might need in representing you. You may be less likely to do it if you don't trust the lawyer and you think they're going to throw you under the bus. So for that reason, these are two ways in which you can explain why it is important to have some sort of identity similarity between the lawyers and those who are accused. Cool. Can I have a next slide? Nice. Okay. So next one is in terms of judges. Again, similarly as before, talking about bias. So very common argument that you're going to be hearing all the time when it comes to judges is explaining why they are biased in two steps. The first one, what is the likely background that judges have? So the very typical phrase of them being likely old white men. I think it is important that you are able to actually justify as to why that is likely. We gave three reasons. The first one is just generally, you often need a privileged background to be able to study law. It tends to be expensive. B, to be able to become a judge, you probably need to be someone who's already respected within the profession, insofar as the peers are likely to be old white men or white men. They are more likely to be respecting someone who looks like them. So again, there's the selection bias from other people, but thirdly, also self-selection. Again, if most of the people that you see as judges are old white men, if you are someone from minority background, you are less likely to put yourself forward or think of that as like your potential career. So even like you self-select against that in the first place. So those are the three reasons that we think are quite straightforward that you are able to give as a reason why their background is likely to be the old white man. Two ways that you can question it. I think the first one is to point out that old white men doesn't mean that they are necessarily horrible conservative people. So often you can point out that the education often leads to adopting a more liberal mindset. So even if these people are old white men, it doesn't mean that they are going to be always like biased, conservative, and terrible. I think the second way is to question whether they are going to be old white men in the first place, pointing out that, for example, there are often university quotas that exist. There's often pressure from social movements to diversifying the profession because people are aware that there is a problem, meaning that there's likely to be a trend of diversifying that sort of the profession in the future. Second claim then that you want to make is that this background does affect the decision-making of that judge. So the claim you want to make is to say that there is probably an empathy or increased empathy that you have towards someone who looks more like you. So I think the common response is that the judge actually doesn't make any subjective considerations, so it doesn't really matter. You can point out that there is actually a subjective consideration the judge makes about the culpability of the perpetrator. So there is a difference whether the judge is going to be perceiving you as someone who just made a mistake or someone who was actually just evil and is predisposed to be bad. So obviously, if you are an old white man and you see a nice looking white guy, preppy boy, you are more likely to believe that they just made a mistake than if it's someone who is a member of minority, where because of your prejudices, you are more likely to believe that they just are inherently violent or something of that sort. So this is how the background can play into the decision making and how the bias can happen. Responding to this again, if you are on the opposite side, then you need to try to say that this is not as bad. You can point out that there is a bunch of checks on behavior of judges. For example, things like sentencing guidelines that are often quite rigid, things like standards by which evidence is considered in court. Or thirdly, you often do have external pressure, for example, by social movements, for example, by liberal media, especially if the trial is something something that is public, very often you just do have pressure against some sort of very biased decisions being made. So that even if the judges could have tendencies to be biased, there are checks and balances to prevent, say, the worst kinds of behavior. Cool. Hopefully that's all clear. In which case I can move on to the next slide. Yeah, okay. So moving on from trials to the last two things, that is talking about the prison system and then the life after prison. So two things that we want to talk about when it comes to the prison system. I think the first one is just the analysis about why prisons are bad. This might sound very intuitive, but actually in a debate that we were quite recently, one of the clashes was just talking about why if prisons are really bad or if prisons are not so bad. So often you want to characterize why prisons are so bad, especially if you want to talk about, for example, why rehabilitation in prisons is unlikely, if you want to talk about proportionality of punishment, etc. Why are prisons bad? Couple of reasons. The first one is things like violence from other inmates or also guards. Two, the fact that you often have issues with overcrowding that leads to things like bad sanitations, etc. The fact that you often have lack of opportunities for education or for work when you are in prison, and if you do have work, it's very often very poorly paid. Or the fact that when you go into prison, you often come into contact with criminal networks. This is not just for people who were involved in those networks previously, but you can also point out that even if you are someone who just made a mistake, were previously very innocent, now they are more likely to get involved with criminal networks for broadly two reasons. I think the first one is because often to ensure self-protection, you need to find a group that you can get involved with, meaning that you often have to join other like criminal networks in order to protect yourself. And B, because often criminal networks do have an incentive to recruit in prisons. For example, in Latin America, often say gangs in prisons have an incentive to recruit people who come there because they know that once these people are going to leave prison, they're going to be facing a lot of stigma. They're probably not going to be able to find a job. So they are the ideal people that then can afterwards work for the gang. So there is active recruitment happening within prisons. So there this is a claim that you can make if you want to explain why rehabilitation is not only unlikely, in fact, you are more likely to be making people worse than they were before and more likely to recommit a crime than they were before. So I think the important claim that you need to also make to support what we have just said about why prisons are bad is why it is hard to improve any of these things. Because it's easy to say, okay, it's bad, but like we can, make some reforms, put in some money, etc., etc. So if you want to make a claim about why it is hard to overcome these problems, I think there is a couple. The first one is in terms of political capital. So you can say that there is extreme lack of political capital when it comes to giving money to prisons or focusing on prisons and prisoners and their treatment. This is for broadly three reasons. The first one is that it's just not a proximate issue for most people. Again, we said people don't think about that they're going to go to prison. So usually if you are voting, you're probably going to be voting for things like taxes that are obviously going to affect you rather than for things like prisons, because you don't think there's going to be something that is going to be important in your life anytime soon. Second is just the perception of criminals as evil people. So if most people think that criminals deserve bad treatment, you do not have the incentive to vote for policies that can improve their lives. In fact, you are more likely to backlash against those policies. So you are more likely to claim that the government is just wasting money on someone who doesn't deserve it, meaning that governments are less likely to be making these policies because they're just scared of the population being angry as a result. And thirdly, there are obviously also lobby groups, for example, victim lobby groups, or in the US specifically, the prison industrial complex that does have a clear incentive to keep prisons existing, keep prisons big, and not necessarily improve them at all. So the impact of this is that you likely have lack of resources, meaning that you can't buy helpful technology. Often the way to improve prisons is to install some sort of technology that can help. If you do not have money, you can't obviously do it. B, you can't get guards. So you're more likely to have all the violence that we talked about. You can't get more space, again, which means that you keep those prisons overcrowded. So this is one way that you can explain why prisons are bad and are likely to stay bad. Second thing is that there's often a lack of information, and the things that you need to know in order to improve prisons are often not collected. So for example, in the UK, there was for a very long time no information at all collected on terms of reoffense rates. So it was genuinely unclear to what kind of things you should be investing in to improve those rates. Or for example, in Latin American prisons, there was often a problem with human rights groups not being able to access them. So again, there was massive lack of knowledge about what's happening inside of those prisons, because there was just no information being collected. But B, also when it comes to prisoners' experiences themselves, often they are not listened to, again, because A, politicians don't listen to prisoners because they often don't vote. B, media often don't have the incentive to, say, interview or give stories about prisoners, again, because they are perceived to be just evil people. So for that reason, that doesn't occur. Because of that, you A, don't have the information of what you should be changing, but B, you also can't hold people accountable. So if there are some sort of human rights violations in prisons and the treatment is really bad, again, you can't hold people accountable because you do not know about it. And lastly, there's often also practical concerns. So for example, because people are often moving prisons, even if you have some nice training programs or education programs, it is just hard to complete them if you are being moved from one prison to another, like every year or two. So all of those things altogether mean that prisons tend to be quite bad places. And this is a way that you can explain it in a debate and explain why it is hard to reform them if a team tries to suggest it. Cool. Unless there are any questions, then we can move to the next bit. Cool. So the last bit is in terms of life after prison. So again, if people want to think about it before, I'm going to list you a big list again. So what do people think that are the obstacles that there are to rehabilitation? So why is it that when people leave prison, they are unlikely to be able to successfully integrate? Yeah, just unmute yourselves if you want to speak.
They're less likely to get a job because they have a criminal record. They're more likely to be ostracized with their family members, friends, the whole society.
Yeah, very good. Yeah, Chris says serious social stigma against convicts, missed years on CV, not used to work, missed experience, gapping career. Yeah, that is definitely true. And involvement with criminals while in prison. Yeah, that links back to the criminal networks that I talked about in a bit before. Yeah. Anything else people can think about? No. When you don't have a job, it's very difficult to get a social circle to regain a support system, which will help steer them away from crime. Yeah. Atya says same crime networks, for example, family and friends. Okay. Oh yeah, I missed this one that Olga said, you believe you've already served your punishment. Yeah, that can also be a psychological reasoning, yeah. Okay, I'm gonna give just a few seconds more if people want to type anything that wasn't said yet. Cool. Okay, otherwise, we can just move. Yeah, so again, oh yeah, Chris says now resent the state, which is definitely a good one as well. So again, people did touch on most of this. So again, the fact that it's hard to find a job. 3 reasons for this that people did mention, things like stigma, the fact that gaps in CV, or sometimes there's a background check that you need to do before getting a job that makes it hard to get some kinds of jobs. The fact that you did learn some behaviors in prison that might not work particularly well in the real world now. Lack of capital. This is related to what Atia said about going back to same crime networks like family and friends, or for example, if you committed the crime as a result of structural poverty, obviously, insofar as your economic situation has unlikely improved in prison, the same problems are likely going to persist even after you leave it. The fact that you lose your relationships with your friends, with your family, this is because either you might just be condemned by them and then you might have nowhere to come back, or the fact that you didn't see your family or your friends for 10 years or did see them for a very short amount of time, not very regularly, means that your relationship just very likely disintegrates. So you're not going to have the support network that you need. And fifthly, you also unlikely to have a community that understands your experience. So again, you are going to come out of an experience that was something that people just do not understand. They never lived through it. They often have the perception that you are just a bad person. No one can relate to you and what you went through when you were in prison, meaning that you are probably going to feel quite lonely in the world that you are now. So for all those reasons, you are just highly unlikely to be able to reintegrate without proper support, and likely to reoffend as a result. So again, all of this is very helpful if you want to explain why rehabilitation or prisons are not really good for rehabilitation, or explain why it is really massively necessary to have support programs for convicts afterwards. I think two extra impacts that you can derive from this. The first one is to point out that there is a principled harm on extra punishment. So if we do believe, and this is generally gets somewhat uncontested, that the punishment should be proportional to the crime, if we believe that the criminal already got that punishment as a result of staying in prison, you can point out that in fact they are suffering disproportionately because they are being consistently punished even long after they leave prison. So it's actually not a proportionate punishment. And secondly, you can also point out that obviously all of these things occur disproportionately across socioeconomic and ethnic lines. So all of this massively exacerbates if you are someone who is from a poor background or from an ethnic minority as a result. Cool. I had an example of a motion where this was used that was quite recent, and why it is useful to have the bunch of reasons and bunch of mechanisms why these obstacles to rehabilitations exist. So at Euros, there was a motion that was given the technology, this house would erase society's memory and evidence of the criminal past of former convicts after their release from prison. So these reasons that we just listed were quite useful in debating that motion, because obviously gov teams, among other things, obviously could claim things like why the stigma is something that is very, very problematic, and why removing that stigma as a result of that policy would help individuals to be able to reintegrate. When we were on opposition, we said, look, the lot of the things don't have to do anything with the stigma. It's about the things like gaps in CV, the fact that you just don't have money. The policy is not solving that. In fact, it's making it worse, because now you do not know who was and wasn't a criminal, so you can't have the support networks or like support policies, like housing policies that you would need, etc., etc. So again, it obviously among other things. So it is useful to have bunch of different mechanisms and think of how the motion relates to different kinds of them. Cool. In which case, this should be everything we have on the slides. So if people have any questions that are related to anything I just talked about, anything Rhys talked about before, or anything in general about criminal justice, you can put it in the chat now, and we can talk about it whilst I'm getting the tab ready.
How would you argue that a current law should, for example, not be a law, or should be not an act should not be illegal? Like, for example, marijuana was illegal in a couple of states in the United States, but now it's not illegal. Like a lot of drugs used to be illegal, but now they're more changing towards rehabilitation and not punishment for taking drugs. So how would you argue that another law is, for example, more targeting ethnic communities and should not be actually illegal?
I think that's going to depend very much on the particular law that you're talking about, i.e., and it's probably like a complete answer to this might require more time than we have as to what the principal justifications for having laws in general are. In general, though, if you're in a debate and you need to establish that something ought not be a law, it is usually the case, assuming there are no principled arguments being made in that round, that one can argue that having that law is something that doesn't actually lead to like people being better off, I suppose, or positive utility-based outcomes. Obviously, then that's something that's going to depend on the particular law you're talking about, i.e. you need to be able to make arguments for why it is that law might or might not lead to good outcomes. And that's something you can't do without knowing what the particular law is. And so I can't give a more detailed answer to that because that's going to be very debate dependent, I think.
Thank you.
Are there any other questions?
Otherwise, I think the tab is ready. Should be ready.
Wonderful. I can go ahead and screen share that then. Give me 1 second.